So, what after all the stuff we've learned about what is right and wrong for administrative officers to do, the next thing which is you're going to be asked automatically is what do you do when an administrative officer has acted badly, or wrongly, or out of the law, or violating natural justice, or acting when they're not even a public officer? What are the remedies in this case? And that is what this class is mainly about. So I'm hoping that after this you will know which remedy to get for someone and at what time. So remember I told you that officers normally act as individuals, but sometimes they act as an authority, representing an authority. So the very first remedy that exists is an appeal. Normally, you can appeal from a decision of an administrative body to the court, normally to the High Court. But this is provided for by the law. The law will normally tell you that if you're not satisfied with the decision of this person, go to this court. But normally it's the High Court. Remember, in the hierarchy of courts, when we talked about hierarchy of courts, it will normally tell you which court you're supposed to go to and for what remedy. So, for example, where you're not happy with what the tax appeals tribunal has decided, uh, it means if you're not happy with what the tax appeals tribunal has decided, it means you appeal to the High Court. So if you imported your clothes from Dubai, you bought them at total cost of 10 million, then you come and they assess you, and URA is telling you you must pay 15 million taxes. It bought the clothes at 10 million. And then you appeal to the tax appeals tribunal, and it's just sides with URA and says no, it's okay for you to pay. You can go to the tax appeals tribunal, I mean to the High Court, and you appeal. That is normally what happens. Even if it's a land tribunal, you may go for a land tribunal case, and the land tribunal decides that this land belongs to so and so, and you're not happy with that decision, you appeal to the High Court. So normally, the quickest remedy is an appeal to the next court. Even for elections, you may go to the EC, the electoral commission may make a decision regarding an election, and you're not happy with it. So the best way is to appeal to the High Court if it's a normal election, or it will be the Supreme Court if it's a presidential election. And that is how it works. So the first remedy, common remedy, is an appeal. The second remedy, and which has most remedies, is what we call prerogative orders. Prerogative orders, you get the notes. Prerogative orders are special administrative remedies which are specifically designed to enforce government duties and powers. They call them prerogative powers because prerogative means you cancel or force someone to do something. And these are prerogative remedies. These ones, we shall deal with them generally, but the other three I told you about, mandamus, statutory, and prohibition. The third type of remedy when an administrative officer hasn't acted well is the equitable remedies like injunctions and declarations. Sometimes you can just go to court and court just declares that what was done by that person was wrong. Just that. You can get an injunction which says that person should not do that act. Yeah. And then the fourth and last remedy are ordinary remedies like damages. And sometimes costs of the case. So sometimes you can get damages. If you applied for a tender, they didn't give it to you, or they gave it to you and you started supplying them and they gave the tender to someone else, so you can get damages. So those are the remedies we are going to look at in general. For appeals, I've talked about it, it's automatic. You appeal to the High Court or to the next court available when you're not happy with an administrative body. That's when we've talked about it. Where it is important is prerogative remedies. What is a prerogative remedy and how is it important? So, just for a brief history, the history of these orders was, like I told you, in law came from England, mainly our law. So these were remedies which were available to the king or to the crown. He could cancel what his officers have done and make appropriate orders to ensure that they carry out their duties properly. and that is how they developed and they came into our law. In Uganda, we have what we call the Judicature Act. The Judicature Act is an act which says how courts should act, how courts should behave. But don't go so much into it, that's for lawyers. But there is Section 34 of the Judicature Act which provides for these kind of remedies. What can you do and when can you do it? So the prerogative orders are the three. You have certiorari, it's called certiorari, you'll see the spelling. Certiorari, it's a Latin phrase. Then you have, that's to quash a decision. Then you can have mandamus, or mandamus, it's also Latin, which means you force that person to act. And then the third one is prohibition, which prohibits that person from acting. Those are the three prerogative remedies that are available. I won't go so much into the legal aspects of it, but what someone does is analysis acts badly, acts without reason, acts out of their law. So you apply for an order to quash their decision, and that is what is called certiorari. Yeah, so you can quash it, or two, you can get an order to prohibit him from doing what he's doing. It restrains it restrains the tribunal or the administrative officer from proceeding in further exercise of their jurisdiction. That's how it works. So if you can remember it, you should. It is certiorari. If you want to use English, then you refer to it as quashing a decision of an administrative officer. That is how you refer to it. So from what we learned in our classes, when can someone apply for an order of certiorari? Do you remember the class on natural justice, where an administrative officer does something without due regard to natural justice, doesn't give a person the right to a fair hearing, acts while thinking the other person is guilty before being proved guilty, and all those things we talked about before. But that's required. That calls for a person to quash that decision and to say this decision should be cancelled because it was wrong. It was not fair, and it led to an absolute miscarriage of justice. There are many cases you can consider where other things have happened, but the basis of this is that under Article 42 of the Constitution, every person who appears before an administrative officer or body has a right to be treated justly, fairly, and shall have the right to apply for a court of law in respect of that decision if it's not happy with it. So this is the basis almost of this thing. So where an administrative officer breaches the rules of natural justice, then you can quash that decision. There are very many cases. We won't go so much into them, but I'll just give you an example. There was a case of someone called John Bosco Oriem. He was suing the Electoral Commission and UNEP because of the decision they had made. Yeah, he was standing for elections. I think they had an election. There was an election campaign going on, and then he was quashing a decision by the Electoral Commission and UNEP to uphold someone's academic documents which were not qualified. You get it? So his question was, this decision of these bodies was carried out badly. They did not give him a fair opportunity to explain himself and why those documents shouldn't have been recognized by the Electoral Commission. So court found that they could quash their decision and get something else for them to do, and that is what they did. So that is an example of how that thing can quash. Another example was someone who owned it was called Ikonda. became a farm. It was a farm in a company, and he was quashing a decision of the Inspector General of Government, the IGG. You know the IGG, we talked about the IGG as an officer. So the IGG made a decision uh, against the company. But the IGG this was a company, private company. IGG is supposed to investigate government entities only. So when they went to court, he said, how can the IGG make a decision affecting me, yet I'm not a public officer? And the judge held, it was Justice Safi Aweri, who died recently, he held that an order of certiorari could be made in this case if you can show that the judicial officer acted in excess, sorry, the administrative officer acted in excess of their jurisdiction. And there are many other cases. So as long as it's breach of natural justice, acting out of jurisdiction, acting without proper powers, acting based on unreasonable considerations, then that is how the order can be granted. Another time is another consideration for certiorari is if a person acts while considering the law, but there's an error on law, or there is some fraud, or there is some perjury, someone lied in court, or they forced him to decide something. In those cases, then you can use the order, or you can get an order to quash that decision because you're saying that decision was made based on a wrong law or in an improper application of the law, and that is how it is. So that is what certiorari is generally. The next prerogative remedy is a prohibition. This is similar to certiorari because remember certiorari quashes the decision, but a prohibition stops that person from continuing to do what he's continuing to do. Like if URA assesses you for taxes and you bring an order, you can be searching certiorari, but then you can also show sometimes that URA is insisting, it wants to actually impound your car, it wants to stop you from paying taxes or whatever it is, or close your company because of a wrong assessment. So you can apply for a prohibition to stop them from proceeding with a scheme which is outside its power. An example of this was the case of someone got a case against the Electricity Commission, and they wanted to take away pipes and all those things, so he could bring a difference. He could bring a case to stop that commission from doing what they are threatening to do. Courts have seen that there's almost no difference between certiorari and the prohibition. Only that the certiorari quashes the decision. It says what you said was wrong, whereas prohibition stops you from continuing to do what you are trying to do, or from doing something you're threatening to do under that improper consideration. So, where you exceed your jurisdiction, or where you lack jurisdiction, or where you acted thinking that you had power to, jurisdiction is the power to handle a certain case. In those cases, it will be held that they can stop you from putting your your actions into practice, and that is how it is. So there are many examples you can think of. You can think of what depending on what the examples I've given you. But in all those ones, you can look at when an official has done something wrong and you want to stop him from continuing to effort. You saw like the case of Nema. That's the best example. You saw the case of Nema where they wanted to come up with the dustbin law. Uh, they came up with a law which was, first of all, they did not consider the law properly. They just came up with it abruptly, they did not, and all those things. So, in this case, if there was not a lot of media hype going on these days, there's a lot of media, so people get together. If they wanted to stop NEMA from enforcing that dustbin law, someone would have brought, first of all, a case to quash their decision or to pass that law, or two, they can prohibit them from arresting and impounding people's cars. Arresting people and impounding their cars. That is how a prohibition works. Those are just one example of it. And that is how how it works. So the third prerogative remedy is called mandamus. Mandamus. It's also a remedy. And this one applies, it's the opposite of statutory because for it forces the administrative officer to act when they refuse to act or to do something when they refuse to do it. So, like if the police impounded your vehicle and there's no reason that they should impound your vehicle, you have a driving permit, you've not had any fines and all those things, and they impound your vehicle. Then, after proving that you don't have a case against you, the police refuse to release your vehicle. You can apply for an order to force that administrative officer to do what is right, and that is what they call mandamus. You force that person to do what is the right thing to be done. Sometimes people may have cases and they award costs and they say, for example, government should pay money to so and so, a certain amount of money to so and so. So in that case, if they've made the order and the treasurer has refused to release the money, you can apply for an order of mandamus, forcing that person to release the money, the person to whom the money was given. And that is how mandamus works. So the difference is statutory quashes the decision, prohibition stops the person, the officer, from doing what they are threatening to do, and then mandamus forces that person to do what is supposed to be done. Yeah, and that's the main difference between those remedies. So they are called prerogative remedies because they force a person to do what they're supposed to do, or they stop them from doing what they are not supposed to be doing, and they come from the order of the state. Yeah. So those are the three remedies. Now, there are grounds for judicial review. There are certain grounds which are considered for judicial review, and you have to consider what you did in our first class. And judicial review is another remedy where an administrative officer hasn't acted well or has it says he has gone out of his powers. Ultra bias means you acted in excess of your powers. That is one ground of judicial review. You apply and say, we want this decision set aside because this person did not have the power to handle that matter. And that is how we do it. And that is one ground for judicial review is if excellence out of it. The second one is to challenge a decision based on jurisdiction, issues to do with jurisdiction, whether someone has powers to do something or not. This is especially with courts or with administrative bodies or tribunals. For example, a tribunal may be set up to handle cases in Kampala district. If the Kampala district tribunal goes and hears cases in Karamoja, then you can apply for judicial review and say you did not have the power to handle that. That is how it would work. The third ground for judicial review is failure to do something based on a statute or a law. That would also amount to judicial review. You can go to court and say, we want this decision to be changed or reviewed because this person did not base his decision on the law. And I'll give you the example of the NEMA Act where they say you cannot come up with a penalty which is not backed by the law. So if they came up with that policy, it can be judicially challenged. Then also the way someone has used their power, like irrelevant. These are the considerations for discretion. Someone can apply for judicial review if someone improperly used his discretion, used it while taking into account irrelevant consideration, was biased, or was influenced. So in those cases, you can also apply for judicial review. And lastly, where there is an error on the face of the record, if it's something which was not done, which was done based on the wrong thing, for example, the administrative officer thought that the law allows people to do something, then, or he thought it prevents people from doing something, then he made an order. In that case, you can also apply for judicial review. So those are the prerogative remedies. Remember, we talked about appeals, appealing from a decision. Then two, the prerogative remedies, which are statutory prohibition and mandamus. Those are the ones which are prerogative remedies. Then we have judicial review when you go to court to review a decision of an administrative body. And those are the considerations that are given. The next type of remedies are called equitable remedies. Uh, when we are dealing with the first class, we talked about the law, we talked about the constitution, common law. Then I told you about equity. Equity is fairness. So we have what they call equitable remedies, remedies which are there to provide fairness in case something is not right. And the equitable remedies are two. Normally, there is an injunction or a declaration. Don't worry, you'll see the notes, I'll summarize them. So, for the equitable remedies, you have an injunction. This is a court order refraining someone from doing a particular act. It's like a prohibition, but this is more of an injunction. It's an injunction. It's a court order to stop that person from doing something, and it can be granted. Uh, the same way as when someone is asking for prohibition. When it's ultra vires, when it's unreasonable, unjust, and all those things. So when you get an injunction from court stops that person from acting or doing something uh, in terms of breaching their administrative duty. There's a case where they said that there are two. Injunction can be to force you or to stop you from doing something. So I won't go so much into that. Then the second equitable remedy is called a declaration. Here you just go to court, so that court declares what was the legal right in this case. Was it right or wrong? Should it have been like that or not? For example, if the police arrested Bobby Wine um, and they stopped him from holding an Easter concert because of politics and all those things, blah blah blah. These are the reasons they gave them. You can go to court just to get a declaration that really was what the police did, was it right on the circumstances or not? Was it right for them to stop it? Then court can just declare that that was wrong, and that is why it stops. So you just want to be satisfied that really this was wrong. Or let court pronounce itself and say it's okay for police to treat someone like that. And that is the declaration. So in most cases where something is not clear what should be done, and someone is exercising their participation, you can apply for a declaration to say whether that thing that was done was right or was wrong. Should it be kept or not? Yeah. And that is how it's also kind of a remedy. So the last remedy that exists where an administrative officer has acted well, the damages. Damages are money which is given by court to compensate someone for what the loss he suffered. So an aggrieved person can complain to court, and then court will give damages. The damages are in different types. One, the general damages. Just the fact that you go to court and you win a case, court can give you damages and say you won the case, so we give you 1 million shillings, general damages. Those are just damages to recognize that your right was violated, someone acted wrongly, so we give you something. Two, they are what they call special or specific damages. These are damages which you prove to court and then court gives them to you. That's why they're called specific or special damages. For example, if you are beaten by the police, and out of the beating and the torture, you had to be taken to hospital, you paid for an ambulance, you spent some time in the hospital, you bought medicine, and your family had to transport itself from where to come and see you. Those are special damages. But the difference between them and the other damages is that special damages have to be specifically proved. If you say that you use transport from Kampala to India, you have to attach a receipt to prove it. It's not assumed. If you say you were in the hospital and then your bill was 1 million shillings, you have to bring the hospital bill to prove it. That's the only way you will get special damages. General damages, it's automatic. If you say I went to the hospital and I spent 1 million shillings, they'll say, someone who has been beaten, who has been slapped by the police, how much money can they give? I mean, how much would it cost to treat him in the hospital? Just simple wounds. Then court will say, no, you're not entitled to 1 million, maybe 50,000 for Panadol or something like that. Those are general damages. But special damages, if someone slapped you, then you lost your tooth, you got internal bleeding, you had to get an operation to put the tooth back, You get receipts and then you prove that to court. So then in that case, they will tell the police or the attorney general to pay those special damages. The third type of remedy, of damages, are called exemplary or punitive damages. These are awarded where someone, an officer has really acted badly and they want to punish him or to punish government. Those are called punitive damages. For example, in the case of, I don't know where you were at that time, but in about 2006, the elections, 2006 elections, there were elections where there was a pregnant, people were rioting and there were many people running around and the police shot bullets. And when they shot bullets, they shot a certain girl, she was called Brenda or something, and she was pregnant. So it was a rubber bullet, but it hit her belly, tore the belly, and the baby came out. She had to give birth, you know. So when they went to court for the action of the police, the court found that the police had acted badly by firing bullets live into the people. They should have fired in the air and things like that. So first of all, she got special damages because she had to be flown. She was taken to Malago, then she had to be taken to Kenya for an operation. The children were born premature, they had to stay in hospital for a long time. So all those bills were paid. Those are special damages. However, the way police acted was bad. So court also gave exemplary damages. These are normally a punishment. You can get general damages of even 100 shillings. You can get special damages of what you got. But exemplary damages are a punishment. So a court awarded about 200 million as a punishment to government for their police officers acting badly. So those are the damages.
Excuse me, sir.
Yes, dear.
There is this scenario. I don't remember whether it was election time or it was a riot when then Besigye was sprayed tear gas in the eyes. So where does it fall?
Yeah.
Is it an impunitive damage or?
Now, that's the thing I'm telling you. First, before you go to that, the question is: was it okay for the police to knock Besigye's car with a hammer, spray tear gas inside him, drag him out like a chicken, and do all that? That's the first thing. Two, someone is saying it was a riot. It was a riot, but did the police act properly in that riot? If it's a riot, does it mean you hit someone's car with your gun and spray tear gas exactly on his face? Is that how you operate? Is it excessive or not? And also the other thing is the way they treated him. So in that case, you're going to go to court. You're going to go to court and say that the way the police acted was really bad because they acted in excess of their power. Find the police have power to prevent riots and to do this, but the way they did it was wrong because they should have done it like this. That is your argument. So if you win that case in court, then court will now determine the damages. First, they may give you general damages. Two, you'll prove special damages. They broke my windscreen. I was playing, I had to go to, I was flown to Kenya for special care and all that. Those are special damages. Then if court finds that the police really acted badly, then they can give exemplary or punitive damages. So that's the situation. In this case of the iron sheets, this case of the iron sheets, for example, which is ongoing now, you're seeing what's going on. They'll ask you when you bail administrative law. The minister, remember we talked about public authorities, the minister is an administrative authority. They have a discretion to decide what to do and how. They got iron sheets, 12,000 iron sheets. In her discretion, I hear chat messages and all that, decided to give the iron sheets to her friends in the ministry, Prime Minister, Minister of Finance, and all these other ministers. You get it? So, in that case, the question is, did this person act properly? No. Then court will say the fact that you got iron sheets of vulnerable people in Karamoja and you give them to people who already even have money. Those iron sheets are not even worth a quarter of their salary per month. Once they give me someone 100 iron sheets, which are worth maybe 4 million. doesn't make sense when you start respecting them. Court can say how you behave is really, really bad. As an administrative officer, you acted out of the jurisdiction. Your decision to give sheets to these people was very bad. It has ashamed the country, it has done that. And then they made, in addition to other remedies, stopping you, quashing, and all those things, court can actually make an order that you pay certain costs or damages to those people or to the government. And that is how it would work. Is there any other question on that? Okay, maybe let me finish. Let me just put the question. So, after those are remedies which you get from courts and administrative bodies. However, these are judicial remedies. There are other remedies which are not judicial, where you don't go to court per se. You go to other bodies which act as courts. But remember, they remain acting as public authorities. So these remedies, I've told you, are judicial remedies, injunction, all those things you get them from court. However, there are non-judicial remedies for administrative officers who have acted on. The first one is the IGG. The IGG is the Inspector General of Government. It's supposed to inspect government officers to ensure that they operate well. If you're doing corrupt acts, if you're not doing things properly, if you're doing all these things, a complaint can be made to the IGG, and the IGG will investigate and make a decision and recommendation. Two, there are commissions of inquiry. You've had commissions of inquiry which are set up to hear what was done, whether it was right or wrong. You've had like the Kosase committee in parliament, they ask whether this was proper or this was proper, and they can also make their decision. Three, you have the Human Rights Commission, but it's like a court, but it's the commission which also hears cases and decides. These are especially to hear cases on human rights violations. So whether a decision to not to give someone a vaccine was proper, whether a decision not to give hospitals was okay, all those things, human rights issues, they'll be handled by the Human Rights Commission, and that is how they work. So the benefits of this is that they are not judicial. You don't go through courts. You don't even need lawyers. You can actually go and just talk. Their process is not so legal. It's legal but not so legal. So you can actually defend yourself. But the decisions they make are binding, and they help to correct the judicial, the administrative officer. And that is how it is. So from the questions you're going to get, after seeing what was done wrong, you're supposed to know which remedy should I apply. Should I appeal that decision? Should I get an order to quash the decision? Should I get an order to prohibit that person from acting? This is really, I'm cheating for you the exam. This is your number one question. Uh, and then, should you get an order to force that person to act? That's one. Then also further, should you get an injunction against that person, or should you just seek a declaration? And then lastly, should you go to the IGG or a commission of inquiry? What should you do? And lastly, what do you want court to do for you? Should court just declare? Should court give you costs? Should it be punitive costs? If you want special costs, can you prove them and ask for them? And that is what this class is about. So after this class, you're supposed to know what exact remedy to give in that scenario. And I think with those 33 minutes, I have covered everything. It's 33 minutes because we were not participating that much, but now we can start asking the questions.